Hi there, my name is John Graff, and I'm a partner in the Higher Education and Litigation Practice Groups at Hirsch Roberts Weinstein in Boston, where I focus much of my time helping clients navigate the complexities of Title IX, both before and since the new regulation was issued in May. It is a distinct privilege and pleasure to serve today as your host during the SUNY Student Conduct Institute discussion of relevance and decorum in a Title IX hearing under the new regulation. With respect to our learning objectives, we could very easily teach separate and probably lengthy sections on decorum and relevance, but we've combined them here because they do intersect. And if we're going to see decorum slip during a hearing, we will almost certainly see it slip in either or both of two areas. First, behavior during cross-examination and/or testimony, and second, the substance of questions asked by party advisors. Just a reminder that under the new regulation, examination of witnesses must be done through advisors, not by the parties themselves. And so we can expect that there will be plenty of advisors from outside higher ed participating who are new to the Title IX landscape, just generally, not to mention new to the hearing space. We can also expect that parties or their advisors, regardless of which side of a proceeding they're going to be on, will come to the process with some emotion and some strong opinions on what is important to a determination and how to get at that information that they feel should be considered by a hearing officer or decision maker. So, we're going to look at relevance and decorum together so we can talk through some strategies to manage these proceedings in a fair and effective way as required under the new regulation. Just something to keep in mind as we work through the material here at the beginning. This is a beginner level training, a quick presentation aimed at providing an understanding of key concepts and requirements for decorum and relevance. In other words, this is all about the fundamentals. It's not by any stretch meant to be an exhaustive presentation. We literally could what if scenarios for many days and still never reach the number of possible situations we're likely to see unfold in real time. For whatever it may be worth, I think that the best training that you'll ever have in this area is the training that you're going to get with every single hearing that you do. Keep in mind, the reg is new and schools are just getting used to it. As schools conduct more hearings, hearing practice will evolve in much the same way as practice does in any industry. And as long as we focus on strong fundamentals from the beginning, we'll be in a great position to grow within the industry. One thing I do want to note for you before we jump into the content. There has been a lot of debate around the new regulation. Some have very strong feelings either in favor of or against it. The law is the law, though, and we are where we are. None of what I am talking about today is intended to reflect any value-based judgments in favor of or against the new rule. Everything that we discuss today is intended to help us ensure that our proceeding meets the requirements of the law as it now stands and related requirements set forth in institution policy. We really can't structure a plan for establishing or maintaining proper hearing decorum without first gaining an understanding of why the Department of Education views decorum as so important within the context of the new regulation. So let's take a quick peek at the why beneath the what before we get into talking about how to actually go about establishing decorum. No hearing in any process, not just the Title IX process, can have any real meaningful value without structure and rules and accountability for individual behavior, i.e., decorum. A hearing, especially one revolving around highly charged issues during which emotions can run high, no matter which side the party is on, can be an unwieldy proceeding. The decorum rules and principles set forth in the regulation are intended to provide structure and stability to the proceeding such that the purpose of Title IX is served with protections afforded to both parties. The department has concluded that in the absence of decorum, there will not be equity in the proceedings, and the final regulation reflects the department's conclusion on that point. So then what does the department expect of us in that regard? Well, it expects us to set rules, and it expects us to make sure that they're followed. And these are two things that hearing officers and decision makers need to keep in mind from go. Their obligation to set standards that will be enforced during a proceeding. Okay, so it's one thing to know that we need to set and maintain proper decorum, but it's quite another to know what that looks like amidst a very new landscape for the higher ed industry. So from a high level perspective, there are a few features that run through any hearing that serve to demonstrate either proper or poor decorum. Which it is depends really on two things. One is how the participants conduct themselves, and two, critically important here, how the hearing is managed by the hearing officer. Important note, The participants most certainly can do their jobs and have a fair hearing as fairness is defined under the new regulation without abandoning proper decorum. The operative question is, how do we get them to do that in a fair and even-handed way? It starts much earlier in the process than many people realize. On your screen are 4 features of proper decorum and 4 features of poor decorum. They are presented in contrast just to aid at looking at this in full context. You can pick either the green column or the red column. If you're focused on ensuring that the green column outcomes obtain, you will likely avoid the red column outcomes. And likewise, if you avoid the red column outcomes, you'll likely see the green outcomes obtain in your hearing. Okay, now that we have a framework for identifying the contours of proper decorum, how do we go about actually establishing it for application in a live hearing? As I mentioned before, it starts very early in the process, well in advance of the hearing itself. Let's have a look. Some principles to bear in mind as we start thinking about how we are going to establish decorum in our proceeding. Remember, we are managing a hearing within a school for one ultimate purpose, which is what? Ensuring access to educational opportunities, which of course is the purpose and requirement of Title IX. We are not running a courtroom. There is no judge, no jury, no clerk, no court officer or bailiff. Although some of the features of the new regulations certainly reflect certain process and protections, such as you might see in a court proceeding, the rules of evidence, whether those be state or federal, simply do not apply to a Title IX hearing. The regulation very specifically requires an evidentiary flexibility because this is not a court and because the interests at stake are somewhat different than those at stake in a court proceeding, especially a criminal proceeding. Here we're looking at what we need to affirmatively require of participants in a process. Understand that in working to create and maintain proper decorum, we're looking at how people do what they do as influenced by their demeanor and state of mind during a proceeding, and that how that in turn impacts the flow and outcome of a hearing. Just a suggestion here for schools that don't already have a decorum policy or that may be looking to assess their own policy against the best practice document, check out SUNY's model decorum document. It's excellent. And the first 4 items on the slide are actually taken directly from that document. The last 5 items are just things that I've learned along the way as a trial lawyer. Granted, we're not in a trial setting here, but they're applicable nonetheless to this type of proceeding. These are things that in my experience help to keep an evidentiary proceeding flowing efficiently toward resolution in a very civil manner. So here we're looking at the things that we need to communicate to participants that they're not allowed to do. Something to keep in mind, hearings are fluid. They are very dynamic proceedings. By design under the new regulation, they're also adversarial in nature. Because they're adversarial, participants, most likely advisors, will at times depart from the calm and even demeanor we hope to be seeing at all times during a proceeding. We need to keep in mind that because we're dealing with human beings who are functioning within an adversarial setting in the hearing and who are dealing with very stressful issues, participant conduct is not always going to be perceived as perfect or even close to it. Fairness, even-handedness require that we give people some flexibility at times to get through the process, particularly those difficult moments that we will see from time to time. That doesn't mean, however, that we tolerate abusive, harassing, disrespectful behavior. There are some things that just cannot happen. They're listed on the slide. The first 7 items shown are self-explanatory. You know the underlying purposes. The 8th item, do not ask repetitive questions. Why would we include that? Because it avoids room to badger or harass a witness. It avoids a situation where an advisor can work a witness over, have them change their testimony by asking the same question over and over and over again. Practical tip here, something you see time and again in trials and depositions. A lawyer will ask the same question several different ways throughout the course of a cross-examination. That may or may not be appropriate during a Title IX proceeding. You need to stay on your toes. Fortunately, the requirement that you make an evidentiary ruling after every question will give you some room to try to notice if that's happening, and if so, whether that's appropriate. Finally, just a reminder to the parties that they remember the purpose of the hearing. That helps to reinforce the importance of compliance. It makes your job a little bit easier, hopefully, during the hearing. Another practical tip, at the start and end of every session where you're briefing the parties on the instructions, just remind them what the purpose of the hearing is. We've talked about the do's and the don'ts and why those things are important. But how do we facilitate communication about decorum between us and the parties or advisors? If your process allows it, or if your process doesn't prohibit it and your institution is okay with it, consider using pre-hearing conferences to communicate with the parties about the hearing. Pre-hearing conferences are invaluable for several reasons, including the fact that they give you an opportunity to accomplish two very important objectives with respect to decorum early on. First, you give the participants sufficient lead time to understand and accept the rules prior to engagement at the hearing so that they have an opportunity to develop their Q&A strategy around decorum expectations, especially important when you have lawyers as advisors because sometimes they may be inclined to go at a witness they would in court, but we're not in court, right? And second, pre-hearing conferences give the participants a preview of your ability to manage the hearing, i.e., the more they feel you know about what you're doing and how to do your job, the less likely they are to deviate from decorum principles. A pre-hearing conference should also give you a sense of where things might start to get intense during a hearing and thus where decorum may begin to slip. That in turn allows you some advance time to start managing decorum around those issues and thus to hopefully enhance your ability to keep the hearing on track. We're going to discuss removal of an advisor in a minute. I'm mentioning it now, though, because if you have to remove an advisor due to their conduct, which is always an action of last resort, you want to be able to point back to some pre-hearing discussion with the advisor about your expectations around decorum. A pre-hearing conference is a perfect way to do that. The rules governing decorum in a Title IX proceeding are not meant to be broken. To be very clear, you are going to have to enforce the rules at some point. That doesn't necessarily mean that you're going to have to take any type of significant or drastic action. That simply means you'll have to monitor and call out certain types of behavior at certain times. We're going to take a look now at how to do that within the construct of the new regulation. When it comes to enforcing the rules, remember you're going to be judged based on two primary features of your handling in a proceeding. One, whether you adequately communicated your expectations, and two, whether you applied the rules even-handedly in real time. That requires you to set your personal opinions about a number of things to the side and focus on the mission objective, which is, of course, to facilitate a fair hearing in which the parties have an opportunity to test the evidence in furtherance of advancing their position. Know the policy, know the parties and the school's rights and obligations with respect to the conduct of a proceeding, and do a solid job of managing a hearing that strives towards good compliance. Note, there's no such thing as perfect in a hearing. The participants and advisors will make mistakes. You will make mistakes at times. Tune out that noise and work toward a good faith, reasoned application of the rules that you can credibly explain later on. We've talked about the participants' behavior, but what about the hearing officer's behavior? The best arbiters are the ones who approach a proceeding understanding that participants are looking to them, the hearing officers, to guide the process and to have the requisite degree of knowledge and skill and confidence and assertiveness to manage an appropriate hearing and to call out inappropriate behavior when it happens, while at the same time regulating their own response, the hearing officer's own response. If you do this job long enough, you will be tested. That is inevitable. Every now and again, you'll get an advisor who wants to see what you're all about or who just can't help but to step out of bounds. You'll get a difficult party or a difficult witness, or there'll be something else that happens. Hearing officers, judges, arbitrators, anyone charged with making decisions in an adversarial proceeding will tell you it is impossible to never get frustrated. The best, most effective hearing officers are excellent at immediately recognizing it before it takes hold and at focusing on deploying a strategy that allows them to regulate the conduct in question and focus on proceeding logistics or requirements and not on their own feelings. They think about what's going to be needed on the back end of a hearing at decision time on appeal with respect to an adequate record of events that show fair handling of any conduct issues, and they act on that understanding. In keeping with our discussion on the last slide, if we have to remove an advisor for their conduct, that can never be the result of our emotional response to that person's behavior. It can only be because that person has ignored a rule that we have clearly communicated after they have been advised once or twice to comply with the rule in real time during the hearing, and their failure to do so is threatening the integrity of the hearing or the rights of the parties. As mentioned earlier, removal is an option of last resort, and it's easy to foresee an appeal challenge based on a removal, at least during the first year where the new regulation is being implemented. Know what constitutes grounds to remove. Communicate with participants ahead of time about the issue, expressing that the goal is to ensure that if the party wants to start and finish with the same advisor, everyone shares a common understanding of what is in bounds and what is out of bounds. If you wind up leaning toward removal in response to an issue, consider what a third party reviewing the decision, one who is not in the heat of the moment, would think about the removal or the decision to remove. That said, we're not making decisions based on fear of appellate review. We are making decisions based on our best good faith judgments in the moment about what is needed during a hearing to ensure that it is fair and that the protection of the parties and the witnesses remains where it needs to be. We are simply considering post-hearing review as a quick reality check on ourselves. Relevance can easily become a trigger for decorum issues. So let's turn to a discussion of relevance to look for an understanding of what it means and to begin thinking about how we make relevance determinations in the moment. A reminder to our listeners that this is not an exhaustive course on relevance, but an overview to discuss key relevance principles reflected in the new regulation. Relevance determinations cause a lot of anxiety for decision makers. I think we can make it fairly simple. If we had to sum up an explanation of the term relevance in one sentence, I would say that relevant information is information that helps a decision maker reach a conclusion about an ultimate issue in a case or about a material issue within the case that is necessary to reaching a final determination. It is always about facts, and the facts play two roles. They construct the story and they underlie assessments of credibility. Both are relevant under the new regulation, subject to a very narrow set of exceptions, of course. When we talk about relevance, we're talking about a way to determine what questions may be asked and what information may be considered in the final analysis. We're not in court, something the regulation expressly reminds us of. As a result, traditional principles of evidence are not applicable, and as a result of that, a lot more information will be deemed relevant in a Title IX proceeding than would be admissible in court. Important note here, that means that relevant information that otherwise might be ruled inadmissible in court because it's just so highly inflammatory that it would be unfairly prejudicial will be fair for consideration in our hearing under the regulation. There is no value judgment here. It is just the law. Question: when are we most likely to have to make determinations regarding a relevance exception? Answer: when it comes to a complainant's alleged sexual behavior. A respondent may want to offer past or subsequent examples of a complainant's behavior to show that that person consented during an event under review in a proceeding. This is very common in a Title IX case involving two students. So though we're talking about an exception to the rule, please don't make the mistake of assuming that having to deal with a question of relevance in this context will be the exception to the typical proceeding. Again, this is why I emphasize the importance of the pre-hearing conference, which may help to tease out some of these issues before you're dealing with them in real time during a hearing. A simple rule of thumb to remember when it comes to analyzing this exception is that unless the defense is predicated upon a claim of consent or identity of an offender, complainant's sexual behavior is not relevant, period. The consent piece of this is tricky. You need to be on your toes when looking at this because there may be facts that suggest that even if consent is an issue, sexual behavior between the parties outside of the event under review may not be relevant. Final note here, the prohibition regarding information speaking to prior or subsequent sexual behavior does not extend in favor of the respondent. A party is allowed to introduce such evidence of pattern behavior, but a determination regarding its relevance still needs to be made in the moment during the hearing. There are very few other exceptions to relevance under the Title IX regulation. Those are largely in the form of privilege exceptions, and that's information that's protected from disclosure pursuant to a legally recognized privilege of some sort. They are largely specific to the law of a particular location, so hearing officers should become familiar with the applicable privileges for the applicable jurisdictions and then try to tease out potential privilege issues during a pre-hearing conference. There's a piece of the relevance analysis that is concerned with what the regulation sees as unfair inferences resulting from a lack of information at a hearing. In some ways, the inference issue is often easier to resolve than other issues regarding relevance, but the regulation mandates that we simply are not allowed to reach adverse inferences under certain circumstances, so we need to be tuned into that issue during a hearing. Why is this so important to understand prior to and during a hearing? Because you have to make relevance determinations in the moment. So if witness examinations touch upon prohibited inferences, you're going to have to determine on the record at the time an advisor asks a question that the material is or is not relevant. That said, there may be some instances where a determination is reached that information is relevant, which may otherwise be prohibited as an inference, were it not for the fact that independent evidence exists that leads to that same conclusion. In sum, there are very few things that can be excluded under the regulation. Make sure you're not required to exclude information under the policy that you must include under the regulation. Remember that although you may not exclude many types of evidence, you can determine the weight to be given to those things. If your school's policy counsels you on how to weigh certain evidence, you just need to check to make sure that information is reflected in training materials. If it's not, connect with the Title IX officials at the school to address the issue. Finally, the regulation requires a relevance determination again in response to every single question asked. That's helpful when it comes to creating a record, but it slows the cadence of a proceeding. So, to the extent possible, use a pre-hearing conference to figure out where the parties stipulate to any facts, such that you might be able to narrow the areas of inquiry during the hearing and thus reduce the number of evidentiary determinations that have to be made in real time. As we close out our session, I'll offer a few final thoughts and key takeaways. As the hearing officer, you're the gatekeeper of process integrity under the new regulation. That means compliance as it relates to the handling of a hearing rests in your hands. That requires you to know the rules cold, to make sure the parties have been explained the rules and had an opportunity to seek clarification and are accountable under the rules. You're not always going to call it right. Your goal is to try to call it right every time, to use good faith in rendering relevance determinations that are rooted in reason and that promote equity within the context of the new regulation. These proceedings are intense at times and they can be cumbersome. We need to never lose sight of the importance of our own objectivity, our own reasonableness and diligence and thoughtfulness and fairness. We need to be confident. People are looking to us to lead them through this process. That requires us to demonstrate poise and confidence throughout. And remember, the facts are the facts. You did not make them, you cannot change them, and it is not your job to defend or prosecute based on them. Your job is to decide an outcome using the facts available to you within the parameters set out in the regulation and in the institution's policy. We are there to ensure that the facts are fairly tested, as fairness is outlined in the regulation, and that they are fairly considered while making sure that the rights and protections available to the parties in the regulation and in the policy are afforded to them during the proceeding. With all of what we have discussed in mind today, we recommend that you consult the variety of resources available through the SUNY Student Conduct Institute for perspective on many of the issues institutions have to work through in light of the new regulation. Again, I'm John Graff of Hirsch Roberts Weinstein in Boston, and on behalf of myself and on behalf of SUNY's Student Conduct Institute, we thank you for your time and attention today. We are humbled to have had the opportunity to share our insight with you.